So your work comp deposition is right around the corner. Well, stay tuned. In this video, I'm gonna bring you into my deposition to share with you my rules for answering deposition questions that I tell my client. Hi, I'm Naomi from Gonzalez Law, legal insights from California attorneys. Welcome to Acing Your Work Comp Deposition. This video is part of our mission to empower clients everywhere through education on the legal process. Please support our mission by liking this video so more people can ace their deposition. So here are my rules to follow to give you the best chance at having a successful deposition. Rule number 1, be honest, so tell the truth. Rule number 2, make sure you completely understand the question. If they ask you a question and you're not sure like exactly what they're asking you, or they're using a word differently than you're used to hearing it being used, either way, don't answer the question. All you're gonna do is you're gonna say, I don't understand. All that's gonna happen when you say I don't understand is they're gonna give you examples or rephrase the question until you do understand. Once you understand the question, then you can answer it. And that's very important because you're gonna be under oath. And if they're asking you this, but you think they're asking you this, so you answer this, you might accidentally be lying under oath, and we definitely do not want that to happen. Any doubt at all what the question is? Just say, I don't understand. Rule number 3, do not guess at the answer. If you do not know the answer, you need to say, I do not know, or I do not remember. Do not guess. There is a kind of exception to this rule, and that is they're going to ask you for a lot of locations and dates at your deposition. For those, instead of just saying, I don't remember, what you're gonna do is really think about it and give them what you do remember. So for example, you may not remember the street address to a place, but you may remember the city it's in or the major cross streets or something that it's by, like, oh, it's by the Costco. Whatever you do remember is what you give them. If they ask you when anything is, they're looking for some sort of time frame. For that, you can give them a date if you know it, but if you don't know the date, you can give them the month or the year or the season, like it happened in the summer. Whatever you do remember is what you give them. If it happened a long time in the past, then you might just say like, oh, I believe it was in the 80s or the 90s. Just as long as you know that the answer is somewhere in that range that you're giving them, you should be fine. Rule number 4, use qualifying words to show when you are uncertain. When they're asking you questions, occasionally you will be unsure of an answer. For those, you want to make sure that they know you're giving your best estimate and not a for sure answer. So that way you have a little bit more wiggle room at the time you're being held to your word. So for example, if they ask you a question, you might say, my estimate is this. Or you might just say something like, oh, I don't really remember, but I think it was this. Or I'm not sure, but I thought it was that. By saying something like that before giving your answer, you're letting the defense know that you're giving your best estimate and not a for sure answer. Also, if they ask you to measure things like the heaviness of items or the amount of times you had to do something per day at work, you would just say about or approximately before giving your answer or give a range. So for example, the box weighs about 10 pounds and I had to move the box about 5 to 20 times per day. Rule number 5, do not volunteer information. That goes back with saying yes or no or keeping your answers very brief. However, there are exceptions to this rule. Make sure to double check with your attorney, see if they have the same opinion on the same subject matter. First, on your job duties, especially if you have a continuous trauma, that's one place that I want you to give all the details that you can as to what you had to do at work, especially physically, what your body had to do. If you have a continuous trauma, you have to actually get on record what you were doing continuously to cause this injury. The second way is your mechanism of injury. How did your injury actually happen? At some point, they will ask you an open-ended question. What happened on this day? Or tell me about your injury, or how were you injured? Something like that. At that point, what you need to do is take them to right before the injury. Where were you? Who was present? What were you doing? Walk them like they were a fly on the wall, right through exactly what happened all the way until you got medical treatment. This is more for a specific injury. Some people will say, oh, I fell and then I went to the doctor. And it's like, wait, no, there's so much that happened. First of all, did you yell out when you fell? Were you on the floor for a while? Did somebody have to help you up? Did you fall on your leg? Did you fall on your butt? Did you fall face forward? There's so many details that need to be discussed in the actual mechanism of injuries. The next place is the injury itself. For these, you want to describe as if you had no pain medication, because that's what the actual injury is, not when it's being masked by pain medication. For each of these physical, you're going to describe them in 3 ways. The first one is, what does it actually feel like? Is the pain stabbing, shooting, pins and needles, burning? What does it feel like? 2 is the intensity. How bad is your pain? Scale of 1 to 10, where 10 being so bad that we need to go to the emergency room right now. And 1 being, oh, if I really think about it, I can sort of feel the pain. So where on this scale are you? The last one is frequency. How often is it like this? Is it like this constantly? Does it come and go throughout the day, come and go throughout the week? Maybe it's constantly there, but the pain alters throughout the day or week. So those are the details you want to provide per body part. If it's a different symptom, like internal or psychological, you want to talk in terms of your actual symptoms, whether that's anxiety attacks, sleeping problems, depression. The next place, and this is specifically for a denied case, you want to give details on how you reported your injury. Who did you report to? Was it in person? Was it over the phone? Was it via email, text message? Who was present in this conversation? What was said? All those details will go into that part. And the last place is activities of daily living, where you do give the details of how this affects your daily life. Those are the places I would tell my clients to give a lot of details. Everything else, yes, no, very brief answers. So that was the end of part 3. In our next video, we'll be talking about deposition procedure, how it starts and ends, and what comes after the deposition. If you would like us to be with you during your deposition, give us a call or text this consult, and we'll be very happy to discuss that with you. Thank you. Bye. Either way, don't answer the question. Rule number 2.